The purpose of today's meeting is to examine the issue of spent convictions and the potential for reform in this area. And we are joined by Senator Lynn Rowan, who has undertaken considerable work in this area and who has beavered away at us to make sure that we had scheduled this address before the recess. And I'm very pleased to say we've done that, Senator. We're also joined from the Irish Penal Reform Trust by Fiona Nickneja, Executive Director, and Michelle Martin, Senior Research and Policy Projects Manager, and you're both very welcome here this morning. We're also joined from University College Dublin by Dr. TJ McIntyre. TJ, you're very welcome back before the committee. And by Mr. Niall Walsh, Manager of the Pathways Centre and Aftercare Programme for Former Prisoners. Niall, you're very welcome here this morning also. So, I have to go through the formal notification of privilege, so I will invite you shortly, and I intended to just invite you in the order that I've just introduced you, if that works for you all. But before I do that, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person or persons or entity by name or in such a way as to make him or her or it identifiable. And members of the Justice and Equality Committee should be aware that, under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. All that said, I'd like to now invite Senator Rowan to make her opening statement.
Thank you, Caoimhghín, and thank you, colleagues, for allowing me to present to you today. I will cover most of the stuff in relation to the Private Members Bill, the Criminal Justice Rehabilitative Periods Bill 2019, which I was delighted to see passed second stage in the Shannon with unanimous cross-party support in February. The bill would expand access to spent convictions beyond those currently allowed for under the limited and unfortunately inadequate provisions of the Criminal Justice Spent Convictions and Certain Disclosures Act, passed by the Oireachtas over 3.5 years ago. I also welcome that we will today be discussing the area of spent convictions reform more generally. My motivation for introducing the bill is based in the rehabilitative principles that underlie the Irish justice system, and my own belief that a person who has committed an offence in the past should be given a fair and reasonable opportunity to reintegrate into society after a set period of time has passed without reoffending. Former convictions for minor, non-violent offences act as a barrier to resources, to the opportunities a person needs to re-enter or enter employment, education or travel after a period of offending behaviour in a way that is not fair or proportionate. While our current law was a welcome first step to legislate in this important area, it is unfortunately not fulfilling its rehabilitative aims. It is extraordinarily limited in scope and in practice, and is simply not accessible to former offenders who need and deserve the benefits from its provisions. Of particular note is the limitation placed by the single conviction rule, where only one conviction outside of minor driving and public order offences can become spent, and the rehabilitative period you have to wait before your conviction is spent being set at a blanket 7 years for all crimes, no matter how long or short your sentence was. My bill therefore seeks to expand fairer access to spent convictions in 4 ways: by firstly increasing the length of custodial and non-custodial sentences that are eligible to become spent, by removing the single conviction rule from the current Act, by making the waiting period or rehabilitative period proportional to the length of your sentence, and by creating a more generous regime for young adults between the ages of 18 and 23 in light of their higher rehabilitative needs. The reintegration and rehabilitation of former offenders is what protects us as a society from further acts of crime. All the international evidence demonstrates that when you have a well-designed and fair spent convictions regime, it works to reduce recidivism and benefits both the individual and society as a whole. When you make access to spent convictions possible for the individual, incidents of crime and reoffending go down, as unnecessary conviction disclosures for minor, non-violent or non-sexual crimes no longer serve as a barrier to progression. As a former community worker, I know firsthand that working in professions such as addiction, homelessness and also in teaching or social work, that when you have experienced similar experiences to those you work with, it is really invaluable. Some of the best community workers and drugs workers I have worked with had previous convictions. However, there are many who will never get the chance to work within the communities that need them most due to old minor offences on their records. Offences that are simply no longer relevant to their lives anymore due to a combination of the passage of time, changes in behaviour and circumstance and major substantive rehabilitation. Since introducing this bill, I've been inundated with heartbreaking testimony from people in these kinds of circumstances. I've heard from students who have reached second and third year of their degrees in the social sciences and have been refused work placement based on old minor offences still being on their record. We have had representations from professionals in high-level positions in the civil service and public bodies who will not apply for promotion due to a 20-year-old mark on their record. This is not only harmful for the individual but detrimental to society, as our laws are literally forcing people out of education, employment and progression. There is a cost to the individual and to society as a whole under the current regime, and it needs to change. This is an area that affects those from all walks of life and socio-economic backgrounds. It impacts on everyone from young men who are point-blank refused entry to the army, young women and lone parents being locked out of education and courses like social work, and people from all sectors of society being prohibited from visiting family members abroad who emigrated during the years of austerity. In cases like these, we are talking about convictions for possession of €15 worth of cannabis, literally keeping families apart. While this issue does affect everyone, the limits of the current law do have disproportionate impact on marginalised, poorer and working class communities. This is made worse by the fact that the Act has no allowance for more than one conviction to become spent, apart from an unlimited number of minor driving and public order offences, making it easy to criticise it as a law written for the middle classes. Removing the single conviction rule is an absolute must in this respect. I've brought this bill forward because a spent convictions law is no use if people can't access it, which is unfortunately the case under the status quo. My bill is compassionate, it's fair, it's balanced and it's the right thing. I hope that you can give it your full support, and thank you for your time.
Thank you, Senator Rowan, for your opening address. I'd now like to invite, I think, is it Fiona is going to take the lead on this? Yeah. Fiona, the opening statement, please. Okay. Thank you.
Thank you, Caoimhghín, Senators and Deputies. The Irish Penal Reform Trust is delighted to meet with the Joint Committee today to speak on spent convictions, and we'll do our best to respond to any questions you might have following the opening statement. For 25 years, IPRT has been promoting policies that make communities safer based on the evidence of what works to prevent and reduce offending and reoffending. One of our long-standing campaigns is for an effective spent conviction scheme in Ireland, one that allows people who are law-abiding and who have stopped offending move on with their lives. Our position is rooted in the recognition that having a criminal record can present barriers to those very protective factors that we know promote desistance from offending, including employment, education and training, accommodation, volunteering, insurance and travel, among other areas. There are two existing schemes for expungement in Ireland. Section 258 of the Children Act 2001, which applies to convictions received for offences committed aged under 18, and the Criminal Justice Spent Convictions and Certain Disclosures Act 2016, which applies to offences committed as adults. IPRT's position is that the provisions in the Children Act generally meet their rehabilitative aims, but that the 2016 Spent Convictions Act is so limited that it fails to fulfil its rehabilitative purpose. Limitations of the 2016 Act have been identified by the present committee in its 2018 report on penal reform and sentencing, the Steering Committee of the National Drug Strategy, in the Mulvey report, and by application analysis of the Human Rights Commission on previous versions of the legislation. To this end, IPRT strongly welcomes the Criminal Justice Rehabilitative Periods Bill 2018, introduced by Senator Rowan, as a positive step towards a better system, and in particular the introduction of a new approach to offending by young adults aged 18 to 23. However, our position is that the bill could go much further to facilitate reintegration and rehabilitation. So our recommendations are as follows. First, remove the limit to the number of eligible convictions that can become spent. This was previously recommended by the Irish Human Rights Commission, and it is draconian that where a person has 2 convictions, other than minor motoring or public order offences, that neither can ever become spent. Ireland's extremely conservative approach to allowing just 1 conviction become spent is an outlier in Europe. IPRT observes that 2 or more convictions does not indicate a propensity for offending, but rather a set of circumstances that contributed to the offending. This could be immaturity and impulsivity, or it could be poverty, mental health, homelessness, addictions, experience of violence, or domestic abuse. Expanded spent convictions legislation is an opportunity to support people who have recovered from such circumstances and moved on from offending to lead law-abiding lives. Second, expand the eligibility of convictions that become spent by increasing the limit to 48 months custodial sentence, as in England and Wales and shortly in Scotland. Any concerns about specific categories of offence that will be included can be addressed separately through vetting for regulated areas of work. 3, incentivise rehabilitation by setting proportionate and reasonable rehabilitative periods. These must be proportionate to the gravity of offence and the punishment received, and should not be so long as to act as a disincentive. The current situation, where it's 7 years for a minor fine to become spent, is completely disproportionate. Amend Employment Equality Acts to ensure prospective employees aren't discriminated against on the basis of a conviction that has become spent. Discrimination can and should also be addressed through policy interventions, such as ban the box campaigns in the US and the UK, where questions about convictions are removed from application forms and delayed until later in the recruitment process. I'll just note here that this, of course, doesn't deal with the other areas of discrimination in terms of accommodation, insurance and other areas. It's only employment. So 5th, recognise that rehabilitation aligns with a victim-centred criminal justice system. Research finds that crime survivors want the criminal justice system to focus more on rehabilitating people than punishing them, by a margin of 2 to 1. Crime survivors want the person who harmed them to be held accountable, yes, but they also want to know that they will desist from offending again in the future. In summary, broadening access to spent convictions supports rehabilitation and reduces barriers to employment, education, housing and more. This in turn reduces the likelihood of reoffending, reduces crime and reduces the number of victims. IPRT therefore asks the committee to consider amending the Criminal Justice Rehabilitative Periods Bill in line with our recommendations, and to progress the legislation as a matter of priority. I'd like to conclude by thanking the committee for its invitation and its attention to this issue. My colleague Michelle Martin and I are ready to respond to the committee's questions as best we can.
Fiona, thank you very much indeed for that on behalf of the IPRT. And we now go on to Dr. TJ McIntyre. TJ, please.
Thank you, Caoimhghín. I'm very grateful for the opportunity to talk to the committee about spent convictions. I thought it might be useful to talk a little bit about the European law in this area, in how it frames national responses. And there are 3 areas of European law that are important. One is the European Convention on Human Rights, Article 8 of which on private and family life shapes what the state can do and what our rehabilitation laws have to look like. And that's what I'll focus on in this statement. There are also 2 other areas which might be of interest to members of the committee, which I'm happy to talk about later if you wish, and that is the role of data protection law here, because data protection law goes beyond what the state does, and it also regulates what private actors do. So the new GDPR will limit what employers can ask for in relation to spent convictions, and it will also limit what search engines can do. It gives individuals a right in some cases to have search results for their name removed where they indicate past convictions. That's obviously a practically important matter, and it's one that I'm happy to come back to if you wish. But to focus on the question of the European Convention on Human Rights, Article 8 on private and family life specifies in effect that convictions can be a part of somebody's private life, so that disclosing those convictions can, in some cases, infringe their right to privacy. And that sounds very unusual from an Irish context where, unlike some common law, unlike some civil law jurisdictions, continental jurisdictions, where there's greater privacy around the trial process, in Ireland, trials are always presumptively public. They're widely reported in the media. Individuals are named in an unredacted form in the media. But the point made by the European Court of Human Rights in a case from 2012, MM and the United Kingdom, was that offences and convictions become practically obscure as they recede into the past, so that they're no longer immediately visible to people dealing with individuals, and that individuals should in effect be given an opportunity to grow, to move beyond past convictions, and that where disclosing past convictions can have an adverse effect on people's rehabilitation, employment, then we have to ask, is that proportionate? Is it necessary in a democratic society to use language of Article 8? Is it necessary for public protection, weighing against that of the impact on the former offender? So what's happened since then is that 3 cases, the case itself and 2 judgments of the English Supreme Court in T and the Home Secretary, and later P, G and W and the Home Secretary, have developed this principle to set out a number of criteria which we can take into account in looking at national spent convictions rules. Now, under the European Convention, there is considerable discretion for member states as to how they want to shape their national rehabilitation laws. But what is clear is that, at a minimum, they must have some form of national rehabilitation law. That law has to provide clear rules regarding when details of offences can be disclosed. The national rehabilitation rules don't necessarily have to provide for a kind of individual review mechanism, in the sense that individuals are entitled to have a case-by-case determination of when information should be disclosed, but it must nevertheless have, at a minimum, clear categories which minimise the risk of unfairness or arbitrary results and try to avoid disproportionate results in individual cases. In this sense, the rules have to be proportionate, so we have to be able to identify a purpose being served by the rule. Are we protecting the public in this regard? And we have to be able to show that the disclosure rules serve that purpose, so that they're not arbitrary. For example, we wouldn't necessarily find compatible with Article 8 a rule that says all old convictions of whatever nature must be disclosed if somebody is, for example, working with children. We could imagine, for example, somebody with an old conviction for dishonesty who had that conviction disclosed wouldn't necessarily be treated fairly, even though it might be appropriate to treat other types of convictions as suitable for disclosure. So in the 2 cases where the UK Supreme Court has addressed this issue, T and P, G and W, what they've done is push out the boundaries of the rule somewhat from what the European Court of Human Rights articulated in And in particular, they stress that it's not just state disclosure that matters here. So it's also disclosure in the context of questioning by employers, even in the context of purely private employment. So even though a job doesn't fit within the general vetting scheme, even though an employer might not have access to state records as such, Article 8 is still implicated if the employer is entitled to ask you about your previous convictions and you are in effect compelled to disclose those convictions. The reason why being that if you fail to do so, you're open to punishment. It will very often be a criminal offence to fail to disclose convictions in that situation, or you might be exposing yourself to disciplinary action or dismissal. In addition, then, to expanding these rules to the private employment context, the 2 UK Supreme Court decisions have stressed that we have to look closely at the way in which we graduate these rules, the way in which we decide when disclosure is appropriate. And in both those cases, the UK Supreme Court has found, contrary to Article 8, rules which provide for either blanket disclosure, as was the case in the case, or rules which provide for blanket disclosure but based on crude criteria. So, for example, in the most recent case, PG and W, the UK Supreme Court held that a single conviction rule, where if individuals have more than one conviction, then all their past convictions must be revealed when somebody is applying for employment, which requires a criminal records certificate. That the single conviction rule was essentially arbitrary and disproportionate. Why? Because it was based on the idea that having more than one conviction shows you've a propensity, you've a track record of wrongdoing, when in fact the second or third conviction might stem from the same incident, or it might relate to a small pattern of behaviour 5 years, 10 years, 15 years, 20 years ago. In other words, that it doesn't tend to show anything at all about ongoing likelihood to commit crime or ongoing propensity. Instead, therefore, the UK Supreme Court has said that national rules of this type, if they're to be compatible with Article 8, should be more fine-grained. They should take into account a number of factors. For example, what was the specific nature of the offence? What were the circumstances around the offence? How old was the person when they committed it? What was the sentence imposed in respect of the offence? Have there been further offences since? How long has elapsed since the offence? And how relevant is that particular offence to the decision being made, be it, for example, child protection or avoidance against offences of dishonesty? And when you measure the 2016 Act against those criteria, I think it shows a number of problems. First of all, as the previous speakers have already indicated, the single conviction rule in the 2016 Act is deeply problematic. To my mind, it is clearly incompatible with Article 8 ECHR and would be found so if challenged in the Irish courts for much the same reason given by the UK Supreme Court in the PG and W case. Secondly, Irish law also applies a very crude cut-off in the limitation to a 12 or 24-month custodial or non-custodial sentence. Again, as with the English law, it's permissible to have a graduated response based on severity of the sentence, but a simple cut-off of that sort, particularly where it's combined with the single conviction rule, seems to me to be incompatible with Article 8. And that's so, in particular, when you think about the different nature of Irish law compared to the English rules. So the English rules that were, the UK rules, I should say, the UK rules that were at stake in the T, PG and W cases, they were all rules that applied to particular classes of employment. They were rules which applied where somebody had to have a criminal background check or a criminal record certificate issued. So in other words, there were cases involving people, for example, working with children, working in sensitive occupations. The English rules more generally, and the UK rules more generally regarding rehabilitation of offenders are much, much wider than that. So those narrow UK rules were limited to particular sensitive situations, where in Ireland, under the 2016 Act, the rules apply across the board, not just in that category. So, to conclude, I'd suggest that insofar as the 2016 Act adopts a very rigid single offence rule subject to these so-called middle-class exceptions for motoring offences, for example, to the extent that the 2016 Act adopts a 12-month, 24-month custodial cut-off and a rigid, then, 7-year rehabilitation period, I think the combination of those factors mean that the scheme as it stands would be found contrary to Article 8. And I'm happy to answer any further questions the committee may have.
Thank you very much, TJ. Thank you for that. And we now go on to the last of our contributors in opening statement, and I'd invite Niall Walsh to address us, please.
Thank you. Good morning, everyone. Thank you for the invite to speak to you this morning. My name is Niall Walsh and I'm the manager of the Pathways Centre. Pathways is the post-release centre for the Educational Service to Prisons, which is part of the City of Dublin Education and Training Board, CDTB. Founded in 1996, the Pathways Centre offers respite to former prisoners in the crucial period after release by providing information, education, counselling, support and referral in a safe and understanding environment. Our work is made up of 4 essential elements: peer support, guidance counselling, educational programmes and activities, and personal addiction counselling. We work with upwards of 400 people every year, assisting them to change their life trajectory and reduce criminal behaviour. An effective spent conviction legislation would assist in reducing recidivism and promoting reintegration through allowing individuals with previous convictions access education. Education has been and still proves to be a proven method of reducing criminal behaviour. It allows individuals to become productive members of society, break away from a cycle of poverty and imprisonment, and improves their life opportunities. This legislation has the potential to lead to safer communities, parents engaged in their children's lives and not in prison. It also has the knock-on effect of them contributing to the tax base and contribute to their community's prosperity. Some of the barriers to reintegration are someone with a conviction may not be accepted onto a college course or be able to complete a college course due to the placement element of the course. If the individual cannot complete and has to drop out, the way fees are structured, they may have to pay to do a repeat first year and in a different course. This has the effect of education being financially impossible, and that path may be forever closed. In Garda Vetting, it affects all areas of life, college and employment. Someone could lose their educational course or employment due to their convictions becoming disclosed. Garda vetting is just that. It is not, but can be seen as Garda clearance. We've had experience of a man coming with a serious conviction over 20 years old, working as a bus driver, and when his employer found out about his conviction through the media, he lost his job, then his accommodation, and eventually ended up back in prison. He'd been doing really well before losing his job. Increased insurance costs. If you have a conviction, no matter the type, when you disclose it to an insurance company, you will pay a higher premium for insurance. Some of these premiums can be very excessive, over the amount of €3,000 or more. Barriers to employment. If an individual must disclose historical convictions, regardless of the length of time since they offended, then they may be unable to obtain even minimum wage employment. Surely they have a right to work and provide for themselves and their families. Section 55 is a perfect example of discrimination. This is where if someone who has a conviction wishes to serve on the board of directors of a charity, they must go to the High Court and get an exemption to serve on the board of the charity. They must have legal counsel and go through High Court affidavits detailing their life story, and the judge decides if it is in the public interest for them to serve on the board of the charity. If you want to serve on another board of a charity, you must go back to the High Court each time. Thank you for listening, and I'll be happy to answer any questions you may have.
Thank you, Niall. Thank you very much indeed. And to all our witnesses this morning for your opening statements. And I have three indications, Deputy Jim O'Callaghan, Deputy Donnacha O'Leary and Senator Frances Black. Deputy O'Callaghan.
Thanks very much, and thank you very much everyone for coming in particular thanks Lynn for producing the legislation. As you're aware, this committee is interested in this issue because we produced a report last year, and I think we recognised in that report, Chairman, that the legislation that exists at present is extremely limited and it fails to support rehabilitation of more serious offenders. And so that's why we welcome the legislation you've put forward, Lynn. Can I ask you, Lynn, since you're the person moving the legislation, what do you think of the proposal put forward by Fiona in her piece that your legislation needs to be expanded upon? There's no criticism of you being made in it, but that it needs to be made maybe less restrictive than is in your bill at present.
I agree, obviously, with the Irish Penal Reform Trust. I think for me, I suppose I was trying to judge what the mood would be like in terms of just bringing people around to the idea that the single conviction rule is not enough and just getting them thinking about what other ways we can approach it. So in terms of my legislation, and hopefully as it moves through the Houses, I mean, I am obviously completely open to working with everybody in terms of making the legislation as accessible and as I suppose liberal as possible for me. So I'm not married to every single part of the bill. It was more just to get the principle there and the conversation going and having a starting point. So I would agree with Fiona's view on the legislation.
I think there's a lot in what Fiona's suggesting as well. That's no criticism of you, as you know. I think if we're going to introduce legislation, we should try to ensure that it, I suppose, deals with the reality of this problem, which is that people can get into difficulties at a certain stage in their life, and you can have a series of convictions which I suppose in years to come are very remote and maybe irrelevant to what you're seeking to do. So I would be supportive of trying to expand it if you can, and we'll support you in that regard. Like I know from my own experience, this is very much a real problem. Since I've been a TD, people come to me. A person came to me very recently who'd been offered a very good job in the state, and it came to the last hurdle, which was the vetting of it. And they had a real fear about the fact that they had a conviction some 15 years earlier for an offence that they had to disclose. And unfortunately, it wasn't a spent conviction, but it had to be disclosed, and it created agony for them. And this was a person who clearly is no longer in any way a threat or anything. So I think we need to do something about it. Just, TJ, in terms of the case, I suppose it's an interesting issue in terms of the Article 8 rights coming into it. But in terms of, say, a right of freedom of expression as well, do you see a conflict with it there? That, say, you'd have newspapers arguing, say, if I had a conviction 15 years ago, 20 years ago, they should be able to write about it. I'm not saying I do, by the way, but if I did, you know.
That's a very good question, Deputy. I should say the MM case itself and the English cases are focusing very much on the question of state disclosure and requests by employers in the course of the hiring process. So they don't address the question of what the media can do. And there are two carve-outs here that are important. One is in relation to the data protection side of things, where, as you know, there is an exclusion for journalistic activities from the GDPR rules that apply to the processing of convictions. And the second is in relation to Article 8 itself, where in a number of cases the Court of Human Rights has said, most recently in a case brought by two murderers against Germany, that it is open to the state to decide to adopt rules that will allow, for example, newspapers to talk about old convictions, to include information about old convictions in their archives, and that's compatible with the Article 8 rights of the individual.
Okay, so like for instance, the example that was given by Niall there of a man who was working as a bus driver, he's not a public figure at all, but the paper was able to write about the conviction some 20 years earlier. That wouldn't be affected by Article 8 rights covering this area, would it? Or would it?
That's also a very good question, because in fact there's two conflicting judgments on exactly that point from Spain and Belgium in the last 2 years. Now, you've put me slightly on the spot and I don't have the details in front of me, but what happened in one case was that the Court of Cassation in Belgium, I believe, took the view that this was information which should be deleted. So information in a newspaper archive about an old conviction of an individual where there was no great public interest in the case could be required to be anonymised. The newspaper could be required to redact the name of the individual in the old online report, whereas in the Spanish case, the Supreme Court took the opposite view and held that the integrity of newspaper archives outweighed the privacy and Article 8 rights of the individual.
Yeah, I think that's obviously a difficult area, and it's an issue that we probably don't have to deal with when we're dealing with Lynn's legislation. I would have thought that the way to deal with the legislation, as Lynn has done, is to try to emphasise in it that relevance and remoteness are the important aspects. Like, is this conviction relevant to something that the person is doing, and is it remote in terms of years which have passed? Because it is clearly the case, if somebody gets a conviction, they serve their sentence, and the sentence denies them of liberty. It has other impacts upon them, but it shouldn't affect them after they've served their sentence. Isn't that just the only comments and questions I wish to ask anyway, Chairman? Thanks.
Thank you, Deputy O'Callaghan. I'm now going to invite Deputy Donegal-Leary, and if I may, just before I do, it's to say that this is Donegall's last meeting of the Joint Committee on Justice and Equality, I believe, and he's going on to other areas of interest here in the Houses. So, Deputy Donegal-Leary, please.
Thanks, Chair. I'll try and pop in occasion.
Good.
I suppose, first of all, just a welcome to bill. I think it's a good piece of legislation. Like Jim, I suppose you occasionally get people come into the clinic and they ask about a situation that they're in and whether they might have heard of the spent convictions legislation, whether it applied to them. And even before the facts of the case are out of their mouth, I'm going in my head, well, probably not. And my experience is that, you know, when the facts are before you, I've had maybe 1 or 2 cases that, yes, it has applied, but far, far more often it doesn't apply. People haven't been able to avail of it. And very often, I suppose just incidentally, and I'm not sure if it even comes across this, I've come across, because I suppose it's an area of ministerial discretion, but it seems to be an issue that holds up citizenship applications as well. People who have 2 or 3 convictions. Some of them could be minor, some of them mightn't be so minor, but generally my experience is the discretion of the minister is not to grant citizenship even when they're maybe in Ireland 10, 15 years, but that's as an aside. Look, I mean, I suppose agree with the point made by Deputy O'Callaghan in relation to, like, I mean, potentially I think we can, and I agree with the approach taken by Senator Ryan. Like, obviously I think it's important that we have this discussion, but I think it's potentially that it can be broadened out, and I'd certainly be happy to support that. I suppose just in terms of questions, I might just ask, in a wider policy sense, I might start with the Penal Reform Trust and Senator Ryan or Niall or Mr McIntyre, if you want to respond as well. How does Ireland rate in terms of rehabilitation and recidivism, and are our rates improving or are they disimproving as things stand?
Thank you, Deputy O'Leary. As of today, we don't know, in that the latest recidivism statistics are due to be published very shortly by the CSO. The probation statistics for recidivism have recently been published, so until we can compare the two, we can't say too much. I think we're about average, but it depends on who you want to compare yourself with. Norway, they were talking about the training and the relationships between prison staff, and they're seeing, so in terms of prison recidivism, post-release recidivism, that the rates are about 20 to 25, but they've been reduced from 25% to 20%. In Ireland, it's in the region of 45 to 47%, so just by comparison.
Okay, okay. And is that an area that we are, has there been much change in that over the years, or have we made progress, or have we fallen back?
Progress is very slow. We won't know again until, so what it is the most recent statistics are the 2010 cohort and their 3-year recidivism rate. So we're expecting the 2011 and 2012 to be published at the same time. Will come us up. More recently, it's kind of crept down a little bit by 1% over the 3 years that have been published. I mean, more generally, what we have to look at are, we think the ages and supporting particular age groups from moving on from their offending histories, particularly the 18 to 25s. What we know about this age group is that they're still in development, and the adolescent brain is still in development, that they have the highest rates of offending and reoffending, but also the greatest capacity for change. And what has been said very clearly by business in the community in England is that young people with recent convictions they're faced by a triple disadvantage in the employment market, that they have no work experience, they don't have access to the same networks that older people will have, and on top of that they have the impact of convictions history. So we definitely have to support young people to move on, and it can be, they use the word seismic, the difference with a young person getting a job early on and moving on, and the impact that will have on future decades in their lives. So we really need to focus on that age group in particular. And just to acknowledge that Ireland has a very, what we think is an effective and generous provision for offending committed by people aged under 18. So we have a system that's very good, but it all stops when you commit the offence after the age of 18. Very few of us would want to be judged by our behaviour when we were 18 or 19, when we're 30, 40 and 50. So we have to do more.
Okay, very well. And I suppose just to ask, maybe generally, I imagine, I don't know this for a fact, but I imagine people who have convictions, or particularly who have spent time in prison, would have a disproportionately high rate of unemployment. Have we any sense roughly what that's running at? Or?
Yeah, so I'm referring to international figures here now, but they say that employment reduces the risk of reoffending between 1/3 and 1/2. And so the Chartered Institute of Personnel and Development in the UK said when people with criminal records find employment, their likelihood of reoffending is cut by 2/3. It's quite dramatic. I mean, we do recognise that getting a job in itself doesn't solve all the issues. There's a lot of pro-social stuff and contributing to society and being part of the enfranchised population that goes with that. So it's receiving a job as part of a broader reintegration into the community. But it makes sense. Being able to provide for yourself and your family is definitely, it supports reintegration and desistance from offending.
I think just to add a point, I suppose, when we kind of sometimes look at employment versus unemployment, but then it's also what jobs are people being pushed towards because of spent conviction. So it's also the type of employment. So especially if, say, you're a young man from a working class community, we had a lot of representations from young men that wanted to join the army, say, and they were excluded because of, say, even one minor offence that was in the Garda Vetting, that came back on the Garda Vetting. So they were then kind of pushed towards lower paid, low skilled jobs where they would have actually preferred to progress in much different directions and were prohibited. So it's not only whether they're in employment or not, it's actually what employment are being forced into, which kind of reinforces inequality, I suppose, and low skilled jobs, and kind of living, closer to consistent poverty than you would if you had different opportunities in the type of employment that you could gain. The other thing that I'd like to point out is, the employment piece is obviously an important piece for rehabilitation, but where spent convictions is now also impacting on is life within the community. So if you are, say, want to go on the summer project with your child, you're now Garda vetted. If you want to volunteer with your son or daughter's GA team, football, so all these other spaces where you as a family will integrate into your community can be prohibited because you have to be Garda vetted, and because it's a blanket approach, so it's not just looking at sexual offences or stuff where you would have to consider whether someone could be going on the kids' summer project or not. But if a drug offence comes up on it, if minor shoplifting offences comes up on it, you're actually being excluded from actually being part of community life with your family as well, which also will have a negative impact then on recidivism.
Like, I mean, it occurs to me that potentially, you know, very often, like, you could have a number of offences related to a single incident effectively. Like, I mean, is there any scope, do you think, for consolidating that particular incident into, you know, for the purposes of spent convictions that, it might be more than 2 convictions, there might be more than 2 serious convictions, but ultimately it was the same act, it was the same incident?
Yeah, so it is covered slightly in the current legislation, and maybe, so it looks at an incident, but then there's all the issue of you have several, like, I mean, from someone who's worked in the addiction sector, I mean, I've supported people that either had an episode of psychosis and ended up, you know, after a week realising they had 10 different charges being dealt with in all different courts then, you know, so it's the management of that. But there is, I don't know whether Fiona wants to comment, in the current legislation there is a provision for a single incident.
Yeah, so where a number of convictions relate to a single incident, it's treated as if one conviction, but it's still limited to just one conviction and one incident beyond the minor public order offences and minor road traffic offences, and that is very problematic if public safety is at the centre of the concern here, which is that 2 separate convictions for shoplifting can be on your record for life and neither of them can become spent, and yet multiple motoring offences which arguably put the public at more immediate and direct danger can be spent without limit. So there's certainly a disproportionality, a disproportionate approach taken in particular to property offences and so-called offences of dishonesty.
Okay. TJ, did you want to come in just on the back of that at all?
No, sorry, I was just going to make the same point regarding the limitation to one incident. And this was actually flagged up in the English litigation since, because as things stand at the moment, if you have, let's say, a conviction for criminal damage and assault arising out of the same drunken incident, then those 2 convictions can effectively be treated together as one conviction. But if you have, for example, a week-long mental health issue and a number of convictions arise out of that, or if you have a conviction for shoplifting in Boots and also a conviction for shoplifting in Marks and Spencer's on the same day, then those 2 convictions are treated as separate. They're not arising out of the same incident and they can never become spent.
Niall, please. Sorry, Deputy. Just Niall. Yeah, just any of the panel, you're very welcome to come in at any time. Please.
Just briefly, I think everyone on the panel here agrees that the current legislation is very restrictive. While Senator Ruan's proposed legislation is a step in the right direction, this is the 4th time that, privileged or not, to be in here trying to campaign through IPRT to get this legislation passed. And I think Senator Ruan's legislation reflects the political realities of trying to get this passed. This leads to safer communities. So while you're trying to, on one hand, balance the public safety, if you allow someone to, and it's not forgetting it, it's just acknowledging that the conviction, it was in the past and they can move on. I can't stress it any simpler. It leads to safer communities if you allow someone to let that part of their past remain in the past and reintegrate back into society.
Thank you for that. Now, Deputy, please.
Just 1 or 2 more, maybe just for TJ McIntyre, or perhaps anyone really, just in terms of, like, seeing from to an extent, this is obviously the wider implications of it, but to an extent this is about information and how this information exists and who has access to the information in relation to a set of convictions. See, under the current regime, and maybe if you have reflections on other regimes, where does the information, obviously it's, the access to it is restricted. I mean, is it deleted entirely, or is it just held, I suppose, in a very secure manner by, I don't know, the Gardaí? How does that actually work in terms of the information that exists or once existed in relation to a conviction or conviction? Like, is it entirely deleted, or is it just held securely, or how does that operate?
No. Well, perhaps I'll just elaborate briefly on my understanding, and then I think Fiona might have something further to say on that. No, the short answer is we're not talking here about deleting records. So unlike some jurisdictions where criminal records are actually expunged after a period of time, what we're talking here about is the obligation of individuals to volunteer the information when they're being asked by employers or insurance companies about convictions, and the ability of the state vetting service to provide information in the context of vetting. But we're not talking about modifying information held on central databases at all.
No, just to echo that, it's about the disclosure so that the records history remains in the state as just what can actually be disclosed, and only unspent convictions can be disclosed. Apart from the area of soft information, the area of vetting, but that's another area of discussion completely.
Okay. And just on that, I suppose, like from your point of view, are you satisfied that the manner in which that's stored and managed currently is secure and kosher and all the rest?
From my perspective, what the big issue here is actually not so much central state records, but rather the media reports. Because what you've seen in the last few years is a lot of newspaper archives, and particularly local newspaper archives, going online. So people's old convictions for assault from 20 years ago might now be visible. A lot of court reports have gone online. So again, if somebody has a conviction from 15 years ago for a serious offence that's mentioned in a High Court judgment, for example, suddenly that's searchable in a way that it wasn't previously. And what's happened, anecdotally at least to a lot of people, is that they've been caught out. That information which has gone into the past has suddenly become much more visible because it's now on the front page of the Google search against their name. And I don't have any statistics on this. This is purely anecdotal, but I've heard more and more complaints from people who feel that it's unfair that information which has been buried has now resurfaced.
Okay. Niall, do you mind me asking, like, I suppose obviously you're working with an awful lot of people, and I suppose a part of your discussions with them is how they reintegrate into society and gain employment and all the rest of it. Do you find that people are discouraged and that people feel there isn't much prospect in getting employment, and that affects how they apply themselves in terms of education, whatever? Like, I mean, are people discouraged?
Very much so, yeah. So you'd have to be, in Pathways, we try help them to be a little bit strategic about the courses that they pick. Should they want to do a law degree, the realities or the practicalities of doing your FE exams are going on, them doors may be closed to you, so they need to be a little bit strategic in the course that they pick. If they want to do social care or work with young people, depending on the type of conviction, they really need to be careful as to, or they may get on the course and spend a lot of time and effort with support of their families and Pathways and other organisations for them never to be able to work in that area that they are qualified and more than capable and use all their life experience, but because of something that happened 20 years ago, it can be soul destroying and very disheartening for people. And then when you see people coming out of prison, they say, well, you done a law degree, that's great, but you can't actually work for it. So it really limits what courses they pick, and it's very disheartening for them. Yeah.
Okay.
Can I just add on to that? I think we constantly as well put the onus in terms of employment on the person who has the conviction or who has, but I think there's an awful lot of information, I suppose, or an information campaign that needs to happen with employers that it's not Garda clearance, it's Garda vetting. And, you know, so many employers use the Garda vetting, just read it that there's something on it and don't give you the job, even though whatever's on your Garda vetting has absolutely nothing got to do with the skills that you've presented, your capabilities, your abilities. And I think we need to put some onus on business and employers to actually use their discretion if they become aware of some minor offences in someone's past, and that they could be more strategic than the individual having to be strategic, that they could be more strategic in terms of, you know, does this particular thing impact on their job, and actually ignore Garda vetting, which is quite okay to do.
Just if I can add on that, you see on a lot of job applications, if they have a tick the box, do you have a criminal conviction? There's no chance of explaining what it is or how long ago it was a minor thing. You're excluded from that stage, you know.
I think, Fiona, you mentioned that, and I think in Britain is there a campaign to eliminate that or something?
Exactly, and it's been extremely helpful. So the Ban the Box campaign, and they've used the same tagline in both the UK and in the US. So that seeks to remove the "do you have any former convictions" from the application form, and the question can be asked much further down in the process, including at job offer stage. And I suppose what we need is a combination of policy change and that public information piece, but also on the other hand supported by legislation. So there is a need for some form of anti-discrimination legislation that takes a proportionate and reasonable approach that happens alongside that, because currently if somebody loses a job, which they may already be performing very well, and that information comes up and they lose their job on that basis, they have no avenue for recourse at all because there is no protection. And there are examples internationally. For almost 30 years, Australian law has said people should not be discriminated against in employment because of their criminal record if the criminal record does not prevent them from carrying out, and the phrase is, inherent requirements of the job. It's described slightly different in Tasmania, where they use the words irrelevant criminal records. About 23% of the cases of complaints that come before the Australian Human Rights Commission relate to discrimination cases on the basis of criminal records, but the number that are found successful is quite small. It was about 6 in 2012. But we would certainly be advocating and asking the committee to consider this, to consider two forms of, I suppose, anti-discrimination legislation. One is that no one should be discriminated on the basis of convictions that are spent, and then the other part of it is that proportionality and the ability to perform the inherent requirements of a particular job. There is real fear, I think, by people who have former convictions. They were never asked about their convictions, they're not relevant to the job, but the fear that that information is going to come up is enormous. Agony, I think, was the word that Deputy O'Caoláin used earlier, and it's very real. There's the other piece, which is people not going for promotions because their promotion might involve international travel, at which point they're going to have to talk about their convictions. So it's not even just getting the job, it's retaining the job and also advancing in your life.
There's also a lot of frustration and a lack of sense of hope for young adults, and that's why we really welcome the provisions for the 18 to 23 to 24. Well, just because somebody may have had a conviction at the age of 19 and they're still affected by 23. Like, we did research in 2015 and one young person said if you can't get a job you're going to go on the rob. I think it's it's an important part to say, and just look at international and European countries that basically have looked at extending provisions for those over 18 from the juvenile justice system, where international human rights law has requested that that's extended to the 18 to 21-year-olds to take into account their development and brain maturity.
Yeah, I have no more questions. Thank you very much.
Thank you, Deputy O'Leary. We're next on to Senator Francis Black, to be followed by Deputy Thomas Pringle. Okay, Senator.
Thank you, Caoimhghín, and I just want to welcome everybody, Senator Rowan, and everybody that has spoken here today. And there's no doubt about it. This is at last where this is a vital issue, and I was also delighted to co-sponsor the bill, Lynn's bill, and this is about changing people's lives for the better. And I suppose there's no doubt about it. Everybody deserves a second chance, and possibly even a third chance. And I know myself, working in the field of addiction and working in the prison services actually with women, majority of and I've been told this by the governor of the prison, that the majority of people who are in the women's prison in particular, because that's the area I worked in, are in there because of addiction or because of maybe coming from family, where there was addiction. And in working with those women, they just want to have normal lives like the rest of us, and the reality is for them, I mean, a lot of them would have been parents, mothers, they want to go back out and live and be treated with respect and dignity like the rest of us. And I think that's what this bill is about, especially when they step into their own recovery. That's what this bill is about, you know. It's about treating people with respect and dignity, and that's the core piece of it. And it's about, obviously, rehabilitation is, you know, one of the core principles of it. And, you know, and getting that rehabilitation and then moving on. And I've met wonderful people in recovery now. You know, I'm in recovery myself, have no shame in saying it, you know, and, you know, from my perspective, you know, recovery can bring you to an amazing place. And I've worked with, you know, women who have, you know, and men who are in very strong recovery and have reached, you know, unbelievable. And it's inspiring, to be honest with you. It's truly inspiring. And not only that, this is about, you know, passing on down to the next generation. We know how, I've worked with families who, when one person steps into recovery, how that ripple effect happens. So when you think about all of that and the whole family gets recovery, you know, I mean, you know, there's no doubt about it, whether it's addiction, mental health, if one person steps into recovery, the whole family gets it. And the children are impacted big time. So for a child to see their mother or father go through a recovery process and rehabilitation and watch them and then go back into college or do something that will, you know, give them back their dignity and respect, whatever it might be, what kind of training courses, that's how they become inspired, you know, and it breaks the cycle, you know, and that's the reality. There's no doubt about it. So this is not just about the individual, it's about society as a whole, and I think that's really one of the core principles around this piece of legislation. So I really do want to commend my colleague, Senator Lynn Ruane, on introducing this legislation. It's absolutely vital. I have a few questions. So I just wanted to maybe connect in with you, Lynn, and ask you a couple of things. And if anybody else obviously wants to come in, that's no problem. So Senator Ruane, which is kind of weird for me to be saying this, Lynn, what are the main arguments or barriers that you find coming up in terms of expanding access to spent convictions? Like what concerns, and also what concerns, you know, do we need to address as a committee? And then the other second question, and I'll just throw this out and I'll come back in again then. Could you give us a little bit more detail on the offences that are excluded from the general spent conviction scheme, as well as the Garda vetting scheme? So just maybe expand a little bit on that, because for me it just seems extremely important, as we see references being made to murder and things like that, which is not what this is all about. So I just wanted you to ask you, and if anybody else wants to come in as well.
Yeah, so fortunately there's been, like, some barriers do get raised and some concerns do get raised, but on the whole it has been hugely positive, and you know, from the public and both politically, people have seemed open and welcome to the idea of expanding spent convictions. And that probably is down to the number of representations that people get in their offices, and they see that it affects almost everybody, you know, in some way, or almost every family. But I suppose throughout the debate, some small concerns get raised. One of those, we had a list of questions, I suppose, posed to us when we tabled the amendments, the legislation, and one of those kind of referenced whether two convictions, more than one conviction, is a pattern of offending. Mm-hmm. And I suppose I don't come at that with that kind of frame of thinking. I kind of go, well, if that's a pattern, also not offending is also a pattern. So if a period of time has passed between you and the last offence, that also means that that's a pattern of non-offending. So it's about how we actually engage with the conversation and how we frame the questions that we ask, you know. So I would much prefer to look at, well, what has happened since the person has left prison? What have they engaged with? How long is it since they've last offended? And they're the patterns that are more important and will more benefit society. I suppose another barrier that came up was about and it answers the next question, I suppose, a little, as well, is around, does expanding the time frame, so expanding from 12-month custodial sentence to 24-month custodial sentence, does that then mean that we include more serious crimes because you're expanding the sentence? So basically the question that was posed to me in the chamber was, what crimes are then included? And again, I kind of look at that question the other way around and go, well, that's not how any spent convictions legislation is framed. It's framed as what crimes are excluded. Because if we are to look at included crimes, we would be making endless lists of every part of law where, so actually you'd be looking at what's excluded. And it is those serious violent crimes. They are excluded. And then what court it's heard in as well, so the district court and the circuit court, is where when you're in court there. But it also combines the sentences, so it might not be a 48-month sentence run. You might have 2 convictions that resulted in more than 12 months over 2 separate occasions and stuff. So it's not even a full run of 48 months, so you can break it up in a number of different ways. And I suppose the victims of crime piece gets brought up as well, because obviously people are concerned that, victims of crime have obviously their own trauma that they have to carry from whatever the offence was. But also it's really important that we support the victims of crime to be able to deal with that. But it's about when the person receives their sentence in the court, where does the relationship end between the victim and the perpetrator? And it's about how we actually have them discussions in a way that's not, I suppose, hurtful or damaging to people that feel they have been wronged by an individual or, by a certain circumstance. So it's about the individual, the person who's committed the crime. Their contract is with the state, when they leave prison. Their contract to not offend is not with the victim. And I think Fiona touched on it in her contribution, where it's framed in a way that there's an assumption that victims of crime want punishment forevermore for the individual, when many victims of crime actually want to see no more victims of that crime from that perpetrator. So in many cases, we believe actual victims of crimes would much prefer to see rehabilitation of a person, so that crime is reduced overall and that nobody else has to experience what they experienced. So they're just some of the things that have come up. But just the second question I kind of answered in the first one, which is that we look at the crimes that are excluded rather than included, because it would be an exhaustive list to write. So it's just making sure that the crimes that we all agree need to be disclosed for particular circumstances in particular employment would remain the same.
Great. Okay.
Did you wish to
If
comment?
I could just echo all of that and say just one overarching piece, that there is sort of a contradiction at the heart of the criminal justice system if we're telling people they must reform, but then at the same time we're telling them they can never forget. And we need to recognise when people have moved on and demonstrated desistance from offending behaviour. But another piece, another area of research are called time to redemption studies, and this is where an examination of when a previous criminal record still holds a predictive value on future offending, and actually it reduces over time. Somebody referred to this kind of area of research earlier, and on average it's 7 to 10 years, beyond which the information is no longer relevant. So in terms of predicting future offending, it's the same as somebody who has never been convicted of an offence before. So arguably all offences, this would not be palatable, but there's an argument that can be made that all offences should be able to become spent at some time in the future following a longer rehabilitative period. And in fact, that is the case in many countries across Europe. We're starting from a very, very conservative pace on these 2 islands. So just to say that we do also need to look, so echoing what Lynn said, but also that we need to focus on the relevance of this information into the future across all categories.
Michelle, yes, please.
Just say, as Senator Black just said, just around the limits on the numbers of convictions and how it doesn't take into account circumstances of the offender. Like addiction is one particular issue that it should, so that's why the convictions restrictions are really important to examine. And then, as Fiona just said, there's a lot of research in France, Spain and Sweden that we should be looking at systems there rather than just looking at England and Northern Ireland.
Thank you.
Back
Just
to you,
one
Senator.
final question. I was just wondering, again, I'll come to yourself, Lynn. Could you give us a little bit more detail on the length of rehabilitative periods outlined in the bill and maybe some of the considerations?
Yes. So what I attempted to do was, I don't have it in front of me, but I created, in consultation obviously with stakeholders, a table which creates like a proportionality scale. So it was an attempt, I suppose, to look at the, you know, everything from fine. So right now you could have a fine on your record for 7 years, which is or community service, which is, you know, like these really minor stuff. And it just didn't feel proportionate, so everything was a blanket 7 years. So what we attempted to do in the table was to set a proportionality. So whatever sentence you were given, or whatever non-custodial, custodial sentence you were given, your waiting period was proportionate to the length of your sentence, you know. So if you only received a 3-month sentence, your waiting period would be shorter. If it was a 12-month, your waiting period would be a little bit longer. So it was to set a scale of proportionality. Because, like, again, this is an area of the bill I'm open to looking at and discussing as time goes on, in terms of, you know, are those numbers arbitrary? You know, why are they set at what they're set at? Can we actually improve them? Does it need to have a proportionality scale at all? Do we just set, you know what I mean, a lower blanket of 2 years, 3 years waiting period, you know? So again, I'm not, it was just, I suppose, an attempt on me to look at the seriousness of the crime and the sentence, and the proportion of waiting time, because right now it's disproportionate that somebody with such a small minor offence would have to wait 7 years. So it was just kind of trying to take that into account, and to work on that as a principle, and whether proportionality should be part of spent convictions.
Okay, back to you, Senator.
No, I just...
You're okay?
Yeah, I'm happy enough. Thank you very much,
Well,
everyone.
thank you for that. Deputy Thomas Pringle, and may I ask, Deputy Conley, would you like to, both new members, all you have to do is that, and you could be first. But today you're not. All right.
I got in there
Deputy
first,
Pringle.
Chairman. We have to be careful of that. Thanks for taking me in. I'd like to thank everybody for presenting here as well. And apologies, I couldn't be here for the actual presentations, but I have read information. And this is probably my first meeting of the Justice Committee, so I'm only getting used to how things are working here as well. And that, so. And I would just like to say as well to Niall that my daughter worked in Pathways on a job placement for summer a few years ago, and she found it very worthwhile in that there, and I think it's a good organisation as well, and I'd like to congratulate you on the work that you do there. I think possibly the question I'm going to ask has been answered, I think, largely by the last contribution. I think a lot of what this, in relation to spent convictions, is in relation to actually how society deals with them rather than how the individuals deal with them. And it's always been put on the individual to actually look to make the changes, not there. It's actually society, I think, that has the bigger onus. And you get this, and I think it's been useful that the debate has been taking place over the last couple of years. Like I remember the original spent convictions bill. I thought I was quite positive disposed towards that when it came in first, because I had a couple of people in Donegal as well who were on to me about convictions that they had 30 years ago and stuff like that, and they still had to disclose them and stuff. And I thought that would go some way towards meeting them, and then this single offence thing scuppered that straight away. So it raised the people's expectations and then dashed them again then when they actually saw that it wasn't helping them. But I think it's probably part of an evolution for us as a society rather than for the people themselves that have the convictions, because they're probably more in tune with what's needed. So I'm just wondering, I suppose it's probably a rhetorical question, but how much of it is about the rest of society getting used to the idea rather than about actual spending convictions? Thanks.
First at that. Okay, Fiona, Lannerai.
Thank you, and welcome, Deputy Pringle. It's interesting. So the thing is, we have an imagined public that has pitchforks at dawn. We have to look at the scale of the issue. You know, there's an absolute silence and invisibility around this issue because, by virtue of the fact that people don't want to disclose their convictions, they're not talking about it, they're not appearing as case studies and information. We don't know. In fact, one thing that would be very useful to take place is for the court service to do some research and identifying just exactly how many people have convictions, and working maybe with the new Chief Information Officer in the Department of Justice, There's a new data and research strategy, all of which is welcome, but to identify the scale of the issue. We do know that in the UK, in the UK, 11 million people, or 16.5% of the total population, has at least one conviction, and proportionately this would be more than 750,000 people in Ireland. Now, you have to be careful of matching. It's not a direct correlation, but it's hundreds of thousands. In Scottish government analysis has shown that 38% of men and 9% of women born in 1973 have at least one criminal conviction. So they've extrapolated to the population as a whole. So at least 1/3 of the adult male population and nearly 1 in 10 of the adult female population is likely to have a criminal record. So the scale of the issue, so this imagined public is actually affected by having convictions histories, you know. Just as every family has somebody who's been a victim of offending, we also know somebody who has committed an offence. So it's huge. I think it would be welcome, but that welcome would perhaps be silent.
Yeah, probably.
Sorry, Senator, just TJ had just indicated, and then I'll come to yourself then. Yeah.
Sorry, just to say one thing in relation to Deputy Pringle's point. I think it's an absolutely fair point, and I think it also reflects a point that my colleague Niall Ó Donnghaile has said of the existing law, that a problem with it is that we treat spent convictions as a kind of prize for rehabilitation. You get this prize at the end of a rehabilitation period, rather than as a tool which promotes rehabilitation. It's no good really giving this as a symbolic gesture at the end of 7 years to say to somebody, well done, you've desisted for that period of time, when a shorter period could be much more effective in promoting rehabilitation in future.
Senator Ruan?
Yes, I agree. And I think when we look at spent convictions or convictions in general, and the issue of society, I suppose, it's not even thinking about what the public will or won't say about this. I mean, I haven't had any negative pushback when I brought the legislation at all. I think people really understand it, but what I think it highlights is as well the disproportionate way these type of laws and regimes impact people of minority groups and lower social classes. Your likelihood of not offending because you're from a lower social class, but your likelihood of being caught because you're of the lower social class is quite disproportionate. You know, so the presence of guards in your communities, the unconscious bias that exists in the justice system, all these things contribute to a disproportionate implementation of our laws. You know, so I think I think people are aware of that, and they know that it doesn't matter what kind of part of society you're from. You possibly do have an offence, or you understand that you know it negatively impacts other people more than yourself.
Thank you, Senator. You want to come in, please?
I suppose the fact that the previous legislation, or the existing legislation with the 1-year sentence, excluded a lot of people. Scary, or something to be just at least acknowledging, is 95% of the prison population in Ireland at the minute are going to be released, so that they're going to be released back into society. These are our neighbours, these are our sons, daughters, cousins. They're going to be back living in the community. And acknowledging the victims in this, not to leave them left out of this in any way. The judge decides the sentence upon sentence. The reality is that sentence only starts upon release, with the barriers to reintegration and all. This legislation will lead to safer communities. I'm sorry for repeating myself on it. I just want to get that point across.
I think it's important. Well done. Yeah. Please.
Really sorry coming in again. So just on the young adults piece, especially on society, you know, a reason why I was so interested in this was when I was younger, and I know I've wrote about it publicly before. I was a young offender myself, and it was only because of the societal interventions that I am where I am, you know, and it was only because people ignored the Garda vetting process to give me employment at a young age in the area of addiction, you know. And the amount of letters that I have a shoebox at home of young men, all young men, from the ages of 12 when they were in Overstown right up to St. Pat's and into Mountjoy as young adults. And they've been my friends since we're kids. And there's a pattern in all of their letters to me that says, when I get out, I'm going to go back to school. When I get out, I'm going to get a job. When I get out, I'm going to join Youth Reach. When I get out, I'm going to stop using drugs. But something happens between institution and agency when an individual comes back into their community, without the societal supports that you speak about in terms of, and Francis has raised in relation to addiction, homelessness, poverty, all these things. So there is an onus on us to look at that age group, those 18 to 24-year-olds especially, that we try and carve out a space for in this legislation to go, there's a huge amount of extra supports needed here, because if I wasn't caught at 17 or 18 with the supports that I was, I don't really know what position I would be in now, and I possibly would have ended up in the prison system, you know, and I don't doubt that for a second. So I really believe that that 18 to 23 section of the bill is hugely important in this legislation, and in any, I suppose, policy we look for in relation to the rehabilitation of young offenders especially.
Thank you for that, Senator. Deputy Pringle?
No, sorry, Chairman.
You're okay? Yeah. Thank you, Deputy Pringle. And Deputy Conway.
Carmila Magad agus fáilte rómh agus is taithí eile a bheith anseo an gcoiste seo I compráda leis an coiste cúntas peibli. It's my first time on the committee, and it's a very different experience in the public accounts to be sitting here sort of listening and learning and debating. So it's a new experience for me. And I'm sorry I had to go out. I like to stay at committees. But just what struck me, Lynn, and well done on your bill, just what struck me is what you've just said to Deputy Pringle. You said, while the issue does affect everyone, the limits of the current law do have a disproportionate impact on marginalised, poorer and working class communities. So that jumps out. And just two or three just questions in relation to the scale. I think it was Fiona that talked about the scale of the convictions, and no research has been done in Ireland, is that right, that the court service are looking at coming up with the figures for the amount of people that have, I just asked a few questions and then stop, just maybe elaborate a little bit on that. Number two, there's a slight divergence I think between yourselves and Lynn in relation to the actual age, and you're suggesting a higher age. And yeah, the last one was just in relation to Niall. Just again, you're very welcome, and I have great respect for your organisation. But just in relation to it would reduce if the spent convictions was acted upon. It would reduce, or it would help to stop recidivism, and it would help. Are there figures? Are there research? What's the best areas to look at in this regard? Because ultimately, I slightly disagree with Lynn in relation to people not being on board. Because certainly with the parole bill recently, there is that attitude that prison is for punishment, and of course victims, absolutely. I mean, we've all been there at some stage with our families. They have to be permanent. But part of the problem is that victims didn't get proper support all along, so it's difficult then to zone in on the offenders. So just in relation to that, thanks.
Doesn't do research that well, particularly on prisoners upon release.
Well, I think in terms of selling it to the public,
So if you're looking for statistics, again, you're putting me on the spot, and I'm at a loss on that. Yeah. That's okay. Like, you're welcome to come out to Pathways and see the effect of someone who engages versus someone who doesn't. So for someone who engages in the educational thing...
No, Niall, I agree with you. My own background is psychology, and I agree with all that. You're preaching to the converted. I'm just thinking about hard facts, or to actually sell it to the public that this is an essential part of rehabilitation. And
so I'd have to draw on international research on that for the minute. So Foster proved, he proved the link between people who engaged in education, obtained an educational qualification. If you're trying to tie that into recidivism rates, somewhere around 30–35%, but it's not a one-size-fits-all because it's such a complex situation, and it's individual basis, so it's dependent on what works. If there was one panacea or one-size-fits-all, Pathways would have patented it and we'd have ran with it. It's really a tailored case for each individual getting out. And if you're trying to sell this, I realise it can be career suicide for a politician to appear soft on crime, and that's not the way to be looking at this. But I realise that you have to sell it to the public. This is my third time stating, sorry for repeating myself, it leads to safer communities for the individual who gets in, and it has a ripple effect too for the children of the people. This is not leaving the victims out, but if someone engages with education, they reduce criminal activity, their children benefit from that, and you break that multi-generational society and back into the communities, and it does lead to safer communities. So I'm not sure if that answers your question or assists in selling it to the public.
Well, that's a response to the last part, but we'll go to the earlier ones. Michelle, are you taking up on Deputy Conley's questions, please?
I suppose IPRT, we'd make a case for a distinct approach for young adults between the ages of 18 to 24. This is based basically on our research report in 2015 around young adults in the criminal justice system. And I suppose the two reasons for this is around the scientific evidence that shows that brain and maturity continue to develop beyond into adolescence and into one's 20s. And also, as Lynn highlighted, around socioeconomic factors that places young adults at higher risk of offending. And in some of the research that in the UK, it highlighted how young men between the ages of 15 to 23 were more likely to sustain a brain injury than any other group. And also in the Department of Children and Youth Affairs, their National Children and Young People's Framework, it goes up to the age of 24. So in line with that, we would call that it would be for up till 24. There's special provisions for young adults in a lot of other European countries. I think between 20 out of 35 has special provisions, and some of them go up to the age of 25, I think in Sweden and in the Netherlands. So it's really more on maturity than on age that should be considered.
Right, okay. Back to you, Deputy Conley.
Just the scale, I think.
Yeah,
Okay.
I can speak just about the court stats, and just to echo, so one important thing is we have to stop talking about victims and offenders as if they're two separate tribes. As Lynn alluded to, or Senator Ruan alluded to there, you know, often they're the same person. And in fact, males in the 18 to 24 age group, the most likely to offend, but they're also by far the most likely to be victims of crime themselves. Ironically, they're also the least likely to worry about that, but, you know, they're twice as likely to be a victim of an offence as somebody who's aged over 65. In terms of the court statistics, there's no research that we're aware of. The Court Service just published their 2018 report a couple of days ago, but it's difficult to drill down into the information. We know that the annual, so recorded crime stats are in the region of 200,000 recorded crimes every year. The District Court, in 2017, there were 290,000 orders made, but not all of those would involve a criminal conviction. The vast majority, this related to 237,000 people before the courts, and 143,000 of those were before the courts for road traffic offences. And we believe that this is why the decision was taken to make minor motoring offences and public order as being unlimited. So we believe that the approach was taken that this would apply to the greatest number of people. But again, that's not linked to the main concern, which is protecting public safety. So we would welcome some detailed research, such as being published by the Ministry of Justice in the UK, but also by the Scottish Government analysis. We would welcome for that to be conducted here in Ireland.
Okay, thank you.
Just follow up on the
Oh, I beg your pardon, please.
Just in terms of, I would have to find the research and maybe submit it to the committee, but I think in Scotland they have done some research, just to follow up on Niall's point, that when they improved their spent convictions regime, they seen a notable reduction in recidivism. Just as, you know, that might be something that we can look to in terms of research of where the public would obviously like to see that it does actually result in a reduction of crime and victims. But maybe I'll find that and send on that. Yeah.
That would be helpful. Thank you. All right, Deputy Conley, are you finished? Or yeah.
Just if you want, just the research that you're referring to, does that give the scale of convictions? We don't know the scale of existing convictions in Ireland at the moment.
In Ireland, no, but I don't know the methodology behind it, but certainly the Ministry for Justice in England and Wales, I suppose, that they did an analysis. They looked at a particular age group at a particular year, very similar to the Scottish research, and it did find that 1 in 3 men born in, I think it was 1971, I think they produced at the time, had a criminal conviction, and 1 in 9 women. And this consistent, actually, Scottish analysis was very similar, as I read out the statistics earlier. So 38% of men born in 1973, and 9% of
It's a
women.
glaring gap, isn't it?
Pardon?
It's a glaring gap in this discussion.
It's a huge gap, yeah. I mean, this, so I think where we're at now, that the Department of Justice has, strongly recognised the need for evidence-informed policy, and they're investing in data and research, and this is very welcome. There's a new government information, or a chief information officer within the Department of Justice. There's a new strategy. It's all very positive, and this should be one of the things that we would certainly like to see them undertaking.
Thank you, Deputy Conway. Jack, would you like to? Deputy Chambers, please.
I apologise, and I'll read back. I've read some of the IPRT's analysis of this, and obviously the need to address the legacy issues that people have, and the positivity around that. Just maybe briefly, what is the pathway for this in terms of your interaction with the Minister on it, and where is it at around the Bermuda Triangle of legislation that we have at the moment? And then also, just on a separate point, I was just thinking about it and hearing your interaction, is obviously the parallel issue to all this is the internet, and the fact that someone may have a conviction and they're labelled with that conviction forever and for more. I mean, has that in some way superseded the legislative intervention here, and what solutions are there in that space? Because I think, we all know employers, there's not only a formalised engagement around what conviction they might have, but there's also the obvious search that occurs and the trawl that happens, and how is that squared? Because that will inevitably remove a lot of people who we're talking about from potential employment.
I'll answer the first question, and then I'll hand over to TJ for the second part.
That may have been talked about, so I don't know.
A little bit, but TJ can repeat himself. But just on the first bit, I suppose the Justice Department has been quite open to the legislation, and we have had lots of positive interactions, and obviously we've had support right across the House at second stage, but that can happen, and then obviously, like you said, it can disappear. But I think there is a will around this. I think I spoke earlier about the amount of representations that each political office gets about convictions. So I do feel that the Justice Department is very aware of the issue, and they know that they've started from a very restrictive starting point in 2016, and we were one of the last countries to introduce spent conviction regime. But the conversations at the time, we went back into all the commentary at the time when the first piece of legislation was being brought in on spent convictions, and it didn't really seem like anyone was sold on the restrictive regime, but they had to get it in at the time. So I think there's been an openness and a willingness to look at this right from the very first piece of legislation in terms of the one single conviction rule and stuff. So I think for me, it's now just kind of keeping that pressure on, and obviously the fact that the committee has had hearings on spent convictions in general, but I do think there's a good chance. I do hope to engage further with Minister Flanagan and his office over the summer to bring this bill back my bill back in to committee stage and to Shannon in the autumn.
TJ, did you wish to come in?
Yes, so in relation to the Deputy's question about the internet, I think you're absolutely right that this is a problem. And of course, it's a problem not just in respect of convictions, but even charges. If somebody has been acquitted, but nevertheless their name turns up in the search, that is a problem. And I suppose there's two questions here. One is a kind of narrow individual question. If you are an individual, you have an old conviction or an old mention of the fact that you were charged with an offence, can you have that removed from search results? In some cases you can. So there is the so-called Google Spain principle, the so-called right to be forgotten, established by the European Court of Justice a while ago. If a conviction is spent, then Google will normally delist that, meaning that it won't show up on a search for your name, even though it will show up in the context of other searches. That makes it practically important, of course, to consider the reach of spent convictions, because if a conviction isn't spent, then Google is much less likely to delist it. And that's a partial remedy. It's a remedy for people who are well informed enough to know about the existence of this right and how to go about exercising it. It's not a great remedy for the average individual who isn't aware of the finer points of European data protection law, and it doesn't really do anything at all to address the wider issue here, which is that of employers, for example, searching against the names of job applicants, looking at the information thrown up, which might be completely inaccurate. It might be information which relates to somebody else with the same name. There are several T.J. McIntyres online. I'm not a science fiction writer. I don't manufacture health foods in Boulder, Colorado. But if you search on my name, these are some of the first results that you see. So there's a wider data protection issue here that I think we might consider, and that is, should the Data Protection Commission be issuing guidance on this point and restricting how employers search against job applicants on the internet? Now, the Data Protection Commission used to have guidance on this point online. It seems to have been taken down in the meantime, but I think it would be very helpful to see the DPC issue guidance confirming that employers ordinarily shouldn't be searching against people online, except having told them that they're going to do that, with the opportunity to make representations on any information they find. In other words, if an employer finds information about TJ McIntyre, they should show it to me and say, this guy who got the conviction, is he the science fiction writer, the health food manufacturer, or the law lecturer in UCD? Yeah. And then on top of that, we should be making sure that employers aren't looking for irrelevant information. And information on old convictions, whether or not they're spent, very often is going to be irrelevant information because it's not going to be relevant to the particular employment. That, to some extent, is a problem that's outside the scope of the current discussion because it's not really within the reach of the spent convictions legislation. It is, though, within the reach of data protection law. And as I said, I think probably the appropriate step here would be for the Data Protection Commissioner to consider reissuing guidance in this area.
All right, Deputy Chambers. Okay, well, we're at this final point, and I don't have, I mean, the questions, I believe, have been well covered over the period. I don't know, Senator, would you like to, is there anything you'd like to say just before we do bring our hearing to a conclusion?
No, I think we've managed to cover everything. And I think the last point that TJ just mentioned around the guidance from the Data Commissioner in terms of people's privacy is an important one to consider. And obviously just to thank you for your time, and we look forward to the report.
Yes, well, two things that I had scribbled here myself, and first of all was you talked about your objective, why you set out in the first place, and I think today has certainly helped to get to a point where I think it's fair to say that you've achieved your objective. You've created that wider address, and that's part of it, and ultimately the passage of the appropriate legislation. We will continue to make a contribution to that journey. We will be preparing a report which will be laid before both houses of the Oireachtas. Obviously now it will be into the autumn resumption period. We're working on another report currently in relation to direct provision, but we would hope very early in the period following our first meeting, the 18th of September, that we would be in a position to adopt the report in relation to today's hearing and the focus of your bill. So without any further ado, on behalf of the Justice and Equality Committee, I'd like to thank Senator Rowan, Lynn, Fiona and Michelle. Thank you for being back again. TJ, once again, you probably knew your seat exactly from before. And Niall, you're very welcome here on behalf of Pathways, and wish you and all concerned the very best. My thanks to the committee. Well done, Frances. I wasn't left on my own at the conclusion. But I would like to thank all the members of the committee, and particularly the fact that two of them were, this was their very first meeting, replacing Deputies Wallace and Daly, Deputies Pringle and Conway. So, listen, a good morning's work. On behalf of the committee, I again thank each of the witnesses for joining us here today, and I declare that the Joint Committee is adjourned sine die.